Welcome to the Law Awareness Weeks at CDC 2023. This webinar is part of Law Awareness Weeks at CDC 2023. It is a collaboration between Pro Bono SG, the 5 Community Development Councils, National University of Singapore Faculty of Law, Singapore University of Social Sciences School of Law, Singapore Management University School of Law, the Singapore Corporate Counsel Association Pro Bono Chapter, the Singapore Association of Social Workers, supported by the People's Association. I am Serene Gan and your host for this webinar. Today's webinar is, what is workplace harassment and how do I deal with it? First, some housekeeping matters. Today, we'll be using Pigeonhole Live for the Q&A session. You can submit your questions at any point in time during the webinar and also upvote on any questions that interest you. If you have a smartphone or tablet with you, just launch your internet browser and enter www.pigeonhole.at into the address bar. Next, key in our event passcode, which is capitalized letters, LAWCDC 2306, as shown on the slide. Alternatively, you can click on the link shared in the chat function to launch Pigeonhole Live on your device. If you're viewing this webinar on your desktop or laptop, you should receive an invitation to launch Pigeonhole. Please note that today's discussion is not intended to substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. And with that, I would like to introduce our panelists for today's webinar, Patrick Tay and Amarjit Kaur. Patrick Tay is the Assistant Secretary General of NTUC and also Director of NTUC's Legal Services and Strategy. Concurrently, he is an elected Member of Parliament and the NTUC Central Committee. Amarjit Kaur is a partner at KhatterWong Singapore and an advocate for gender equality. Patrick and Amarjit, thank you for joining us today.
Thanks.
I would like to hand over the time to Amarjit, who will be giving us a brief overview of the law on workplace harassment.
Thank you, Serene. Good evening, everyone. It's a pleasure to be here with you today. I want to start off by setting the scene with some key statistics on workplace bullying and harassment to highlight that this is a pervasive problem in Singapore and one that we should be talking about. So I start off with the fact that almost 1 in 4 Singaporean employees indicated that they had been bullied in the last year, in a single year, in 2019, in the Kanta Inclusion Index. Now, that's quite a startling figure. I'm sure you will agree. And that's for workplace bullying. If we go into harassment, specifically sexual harassment, 4 out of 10 respondents in the Aware Ipsos survey indicated that they had suffered some form of sexual harassment in the 5 years leading up to the survey. I think that shows us this is a topic we should be talking about and that there are real concerns about this. Now, if we go into our actual content for the day, what is workplace bullying and harassment? And I think setting the foundation for this is crucial because what the statistics and the studies have shown us is that there is a knowledge gap in terms of what constitutes bullying and harassment. And that feeds into the consistent underreporting of these issues. Because people wonder, is this bullying? Is this harassment? Is it serious enough? So I think there is some value in doing a 101 on this topic so that we at least create some awareness before we go into the specific examples and we then address your questions. If we look at workplace bullying and harassment, this occurs in many different forms, right? So we know that there's verbal abuse. We've all heard examples of bosses hurling abuse at their staff, staff to each other, etc., vendors, customers, all of that forms part of the workplace, okay? So the workplace is not just boss to subordinate. The workplace is all relationships that intersect at the workplace. It could be vendors, customers, third parties that have something to do with your workplace. Verbal abuse is, denigrating someone, using vulgarities at them, putting them down, etc. Right? And then we go into physical abuse, psychological abuse, and harassment, which I talk about in some detail as we go further into this topic. Now, bullying is usually a pattern of conduct. It can be blatant, it can be subversive and subtle, it can be active or passive. Okay, it's usually some form of aggression, and it occurs across a spectrum of varying degrees. Now, such behavior usually violates a person's dignity and self-respect, creates an unfavorable work environment, and it effectively poses a risk to the person's psychological safety, health, and well-being. If we go further into this, it takes place across different modes of communication, right? So it can happen face-to-face. During COVID, we realized as we work remotely that workplace bullying and harassment found its way through this new form of work, through online modes of communications. So even if employees work remotely, they do remain susceptible to such bullying and harassment. It may also occur outside the office. So when we think workplace, we think confines of office or at home if you're working remotely. But effectively, it can also happen at third-party premises, such as a vendor's premises, customers' premises, company events, business trips, and other work-related occasions. So it's important for us to understand what is the context of the workplace. It's not purely the physical workplace, it extends beyond that. Okay, so let's go into verbal abuse, right? As examples, verbal abuse may occur face-to-face, written text, so even WhatsApp messages, emails, social media, all of that may constitute a form of verbal abuse. Shouting, hurling abuse, berating, mocking, racial, homophobic slurs, etc. Now, verbal abuse may cross the boundary into a form of criminal, actionable criminal behavior if it constitutes criminal intimidation, right? And that refers to a threat to cause injury to body, reputation, or property, or body or reputation of anyone that you know. So verbal abuse may actually be serious enough to form a criminal offense. And this would be done with the intent to cause alarm, to cause a person to do an act he's not legally required to do, or to stop a person from doing an act he's legally required to do, okay, or legally entitled to do. Now, we go into physical abuse. Physical abuse is fairly obvious, right? Slapping, punching, pinching, poking, various other actions you can imagine, which may cause harm to someone, right? Pushing someone down, backing them into a corner physically, backing them into a wall, etc. All of this may constitute physical abuse. Now, more extreme examples of physical abuse may actually constitute criminal offenses. So we recognize that this is a spectrum, right? So some of the actions may be less serious and more innocuous in nature. But as we go through the spectrum, it can constitute use of criminal force, voluntarily causing hurt to someone. I've got an example in my slides of a case where criminal force was actually used by a lawyer who caused hurt by slapping a staff on their cheeks, poking another staff on the forehead. That's an example of workplace bullying and harassment. Okay. And if we talk about physical abuse, when we go into the sexual harassment section, there are acts of physical abuse or physical harassment which also may constitute criminal offenses. Psychological abuse. Now, psychological abuse is an insidious form of abuse because it is abuse that plays on the mind. And examples of psychological abuse, gaslighting is a word that has recently come into our lingo, right? And it's understood where gaslighting is actually undermining someone's sense of perception of their reality, denying their reality, denying their view of things. It could also be undermining an employee in front of their colleagues, manipulating them, isolating, marginalizing them, ignoring attempts to communicate, stonewalling them, ignoring messages, emails, etc. from them, pretending they don't exist, and diverting work and opportunities away to other colleagues. Now, I'll share an interesting example of psychological abuse. Someone in a tech company actually told me that if you want someone to feel like they're not wanted, what they do is they call for a meeting in a glass meeting room. Everyone is called except the person they want to send the message to. So that's an example of psychological abuse, right? Where you play on their mind that they're not part of the group or they're not wanted, all right? Now, if we go into workplace harassment, it's actionable in Singapore under the Protection from Harassment Act. We will refer to it as POHA in this session, where one party at the workplace demonstrates behavior that causes or is likely to cause harassment, alarm, or distress to another party. And this conduct may be intentional or unintentional. What does this do? It violates a person's dignity, creates a hostile work environment, and it can take different forms, right? Sexual harassment, threatening, abusive, insulting language, cyberbullying, unlawful stalking, doxing, which is publishing an individual's personal information, and also offences in relation to public servants or public service workers, which Patrick will touch on when we get to this. Okay. The POHA sets out examples of what constitutes harassment. You will see that in my slide, intentional harassment under Section 3. POHA, I'll give you an example. Bobby and Jenny are co-workers. At the workplace, Bobby loudly and graphically describes to other co-workers Bobby's desire for sexual relationship with Jenny in an insulting manner. Now, Bobby knows Jenny is nearby and Jenny can hear this. He still proceeds with the intention to cause Jenny to be distressed. Jenny, of course, is distressed. Bobby would therefore be guilty of sexual harassment under Section 3 of the POHA. This is intentional harassment because Bobby knows Jenny could hear and he went ahead to say it anyway. The next header is unintentional harassment. So even though it's not the intention to cause harassment or to cause distress or alarm, it could still constitute, it could still fall under Section 4, right? So let me give an example. Kenny, Clara are co-workers. Kenny posts some messages on a group chat which their whole department can access. Kenny's messages have graphic and inappropriate comments about Clara's physical appearance and characteristics. Now, a colleague shows Kenny's message to Clara. Clara is distressed. Now, Kenny didn't intend for Clara to see this, but it was brought to Clara's attention. Kenny is still guilty of sexual harassment under Section 4 of the POHA. Now, these are just examples to give you a sense of the type of behavior that could fall under these various headers in the POHA. This brings me to the next topic, which is sexual harassment. Now, sexual harassment it definitely happens in Singapore based on the statistics that we shared from AWARE, but it is one of the most chronically underreported things that happen at the workplace. Because sexual harassment is usually shrouded with guilt and shame, and the victims of sexual harassment usually second-guess themselves a lot before they ever raise it, right? For good reason, as we will go into later, all right? What is sexual harassment? Why is it important for us to go into the question of what is sexual harassment? I'm going back to the AWARE survey because before AWARE set out examples to the people they were surveying, 3 in 4 said they had encountered sexual harassment. After they were given examples, it jumped to 4, right? 3 in 10, it jumped to 4 in 10. So what does that tell us? People don't know what constitutes sexual harassment. And I think training and creating awareness is critical, right? Because it's only when people know what is acceptable behavior and what is unacceptable behavior that we make strides towards a healthy and safe workplace, all right? So let me go through some examples. Sexual harassment generally refers to the making of unwanted sexual advances, right? And it takes on different forms. Whether you're on the receiving end of sexual remarks, photos, texts of a sexual nature, being asked questions that are inappropriate about appearance, body, sexual activities, and being touched against your will, okay? That's inappropriate physical contact. Now, in terms of recourse, right? What can victims do? The POHA is a good port of call, right? But some of these actions, as I said earlier, may also constitute criminal offenses, right? Such as outrage of modesty and even rape. So in my own experience, we recently had a case which actually involved a rape after a workplace event where a fair amount of alcohol was imbibed, and it actually went to that end of the spectrum. So there may be some actions that do not constitute criminal offenses, but it doesn't mean that you can't get protection because there are still avenues of recourse. And there are also other actions which are criminal offenses. So it's important to realize that there is a whole spectrum and there is protection across the spectrum. Okay. Now, is there recourse? This is a question that always comes up, right? I've been bullied, I've been harassed. What do I do? Can I do anything? Is there anyone out there to help me? And the answer is yes. So usually what we would say is start off by understanding the lay of the land in your company, right? Familiarize yourself with the policies that the company has put in place. Usually there will be a code of conduct, an employee handbook, which are the house rules of the company, right? They set out the behavior that is accepted and not accepted within the company. So it's important to understand, and knowledge is power, right? The next thing you need to understand is, does the company have a grievance procedure? And if the company does, familiarize yourself with it, whether it's an employee assistance program, a confidential whistleblowing channel, or just a small line there saying, if you have any problems, please let HR know. You need to understand what the company's own internal processes and policies are so that you can make use of them when you need to. Usually we will say, don't go and escalate externally first. Speak to your HR, speak to your manager, speak to your allies within the company who can help you raise the issue, right? Sometimes it also makes sense to speak to the person who's harassing you. Now, I know that feels counterintuitive, right? How am I going to speak to the person who bullies me, who gives me nightmares, who's harassing me? In certain situations, they may not even be aware that their behavior is coming across as offensive. They may not have realized that, what they're doing is inappropriate or is affecting you in a particular manner. So it's a lost opportunity to raise it with the person directly and give them a chance to correct their behavior, to make amends. Now, it doesn't happen in every case. You may say, well, if it's benign, they may back down. But what if the person is a narcissist and is just going to deny it and it's going to make me feel worse? So essentially, nobody knows the perpetrator better than you, right? If you're the victim of bullying or harassment. So this is a personal call, but it's also an option, right? And then we go into the other more formal avenues of recourse, right? There is the Tripartite Alliance for Fair and Progressive Employment Practices, which is known as TAFEP. There is the Singapore National Employers Federation, SNEF. There's NTUC, of course, and we have Patrick representing. And AWARE is a well-known gender equality organization that can help, okay? And then we look at POHA, as we explained, the POHA is intended to protect specifically from harassment. So that avenue is always there. There's also the criminal offenses that are in place. So filing a police report if appropriate and commencing civil action if appropriate. Okay. Now, if we go into the POHA court, the POHA court, if you go to the state court's website, it's brilliant because there's a resource there which helps you enter the information. And you can also go in for an expedited resolution of the issues. You can do this without lawyers if you choose that avenue. And it's intended to provide cheap and effective resolution of these problems. And there's also an option for parties to settle because these sorts of disputes are actually perfect for settlement. And to the extent possible, they should be resolved amicably. And I think that should be it. We can go into how employers can harass, can address harassment later. Over to you, Serene.
All right, thank you, Amarjit. I think that was a very information-packed session, very useful tips, at least, letting you have a basic understanding of what might constitute harassment. I'd like to hand over to Patrick to share a little bit more of his thoughts on recent developments.
Yes, thanks, Serene and Amarjit, for sharing with us, the key 101 areas of this space of workplace harassment and bullying. I think there's lots of developments in the past, I would say 9 years since the Prevention from Harassment Act was passed in 2014. And we see lots of developments. I think I thought useful this evening to share some of these developments, the past couple of years and moving ahead. And if you look at the last couple of years, I think there was a couple of amendments to the Prevention from Harassment Act. In particular, Amarjit alluded to some of the important sections. I won't go into the details, section 3, 4, 5, and as well as 7, which was alluded to. But it's an interesting section, it's actually section 6. Yeah, something quite close to my heart, because section 6 provides enhanced sort of deterrent punishment against or would-be offenders who, through certain acts of violence or even threat of violence on public service workers. This unique definition in inverted commas called public service workers. And this in the Act, it refers to a schedule, and the schedule has been amended, if I recall correctly, twice over. And now it covers quite a wide spectrum of workers in a frontline public service environment, from the workers in the bus interchange to private security officers to even in the healthcare setting. I think that's one big one that came up recently on TikTok, in a healthcare setting. Likewise, in many other public service environments, including in public educational institutions, as well as even certain drop-in centers and social service centers as well. So the definition of public service workers has been enhanced quite widely to cover quite a long list in different scenarios, different premises in a public setting. So these people generally are employees who are providing public service and usually in the front line. And therefore, this added protection is to help deter against would-be perpetrators. So that's one key development that has came up in the past couple of years. Second, of course, is the POHA court, which Amarjit alluded to earlier. I think now we have a dedicated court looking at POHA cases, and really, I just want to lend weight to the fact that the state courts has through its website provided quite extensive and quite a comprehensive flow charts and access to information on any of the claimants who wants to file a POHA claim against the perpetrator, and lots of information there, and really step-by-step guide to help you to navigate the intricacies of POHA and how to file a workplace harassment claim in that instance. And that's the other one, a dedicated service, and of course a more expedited procedures and processes. As we know that the POHA court, or the POHA actions, why is it better than notifying the police or even taking a civil claim? Of course, there are certain expedited orders that can be granted, protection orders, even compensations, and even some sort of criminalizing of certain acts and behaviors of perpetrators. So that's the second key development, POHA court and the ease of access to justice. And third, of course, it's Amarjit alluded to that, the tripartite partners. I think in the labor movement, generally in a unionized company and unionized environment, union members can actually approach their union leaders and the unions to assist them if they feel they are aggrieved or harassed or distressed, or they have a grievance. So there's a proper grievance procedure that's prescribed, usually in a collective agreement or in some form of document or provision of law in the Industrial Relations Act, as well as in the industrial setting. But over and above that, even in the non-unionized company, besides the POHA court access, of course, you have access to making police reports, civil claims. But more importantly, Amarjit alluded to TAFEP, Tripartite Alliance for Fair and Progressive Employment Practices. As you know, one of the key developments of TAFEP is that, lo and behold, there was an announcement that we're going to have a piece of new legislation called the Workplace Fairness Act come next year. It's a workplace fairness legislation. It's not passed in law yet, as law yet. So we hope to see, the full details out next year. But in fact, I'm part of the working committee, the tripartite committee, looking at this piece of legislation, and we have released a deck of recommendations, 22 in all. A big compendium of areas that we're looking at, from protecting whistleblowers to protected characteristics to how we are likely to adjudicate or even provide access to filing complaints against workplace fairness and sort of an anti-discrimination piece of legislation. However, I just want to at this juncture flesh out that as part of the recommendations, one of the questions asked was, how about workplace harassment? So the likely shape of the legislation will be that workplace harassment will be addressed through the POHA, and of course you still have access to TAFEP. However, the workplace fairness piece may not and likely not address workplace harassment and bullying, since we already have the POHA. But however, if workers feel that they're discriminated in the course of in the workplace, either pre-employment, in employment, or in the exit of employment, or termination of employment, or even being laid off, then the workplace fairness piece of legislation will come in. if they come within the purview or the ambit of the protected characteristics. So yes, it's a thin line between bullying, harassment, and discrimination. But I just wanted to provide some clarity because of the deck of recommendations that have come up. So there'll be a bit of a dichotomy between workplace bullying and harassment vis-a-vis workplace fairness, or should I say discriminatory practices. So that's the latest fresh from the oven developments. And we'll expect to see this piece of legislation come in, introduced in Parliament second half of next year. That's from the Ministry and the Minister of Manpower himself. And we hope to see how it turns out. But of course, till then, I said in a unionized environment, come to the unions, come to NTUC to seek recourse. And if you are in a non-unionized environment or you're not a union member, you can still file a claim through, if you are in the workplace feeling aggrieved, through TAFEP. At the same time, if it's situations that fall within the POHA, then you can have that and be a claimant through the POHA court. So these are some of the key developments I thought useful. And one final piece is that the tripartite partners have also come together to work out a small booklet of a tripartite advisory on managing workplace harassment. So I think that's a useful document you can refer to for employers and many SME owners out there or even HR practitioners who are not too sure where to go if you want to introduce some of these guidelines within your HR manual, within your company SOP or practices. You can pick and leave from there. All these are readily available on the TAFEP webpage and website, and you can actually download them. And I've personally gone through them and scanned, and some of these documents are quite comprehensive and serve as good templates if you're trying to scratch your head and think where to start, especially when you introduce some of these procedures in your workplaces. So these are, well, in a nutshell, some of the key developments and pieces that are happening. And I'm, like I said, as and when new developments come, happy to share more.
Can I just jump in here, Serene?
Sure.
Firstly, I want to second what Patrick said. The tripartite advisory on managing workplace harassment is brilliant. The template in there is excellent. So if companies don't want to spend on legal fees to draft these templates, you have readily available templates, right? So it comes at no cost and they're very well drafted, right? So as a starting point, all companies strongly urge to put this in place. Why? Why should you put this in place? Because you are setting very clearly, you're setting out parameters of what you will not accept. And workplace harassment is something you cannot accept. So going to your next point, Patrick, the earlier point you made on the workplace fairness legislation, which is a brilliant idea, very much needed to set the scene in terms of acceptable workplace conduct and unacceptable workplace conduct, particularly where discrimination is concerned. I have two observations on that. I think it's wonderful that we have introduced protected characteristics, including mental health and disability.
Yes.
Which I think is very long overdue.
Caregiving arrangements.
Caregiving arrangements, pregnancy, including breastfeeding. So I think there's a lot of advancement in that, which is very laudable. I also think it's wonderful that companies need to put in place grievance procedures. Okay, so for employers, if you don't have them, don't scramble, come mid next year, start now. Okay, put in place your procedures. And it's also very important that the recommendations indicate that companies should not tolerate retaliation.
Yes,
whether it's for discrimination or harassment, which I think is good, because even though this piece of legislation is not intended to cover harassment, to avoid overlap with POHA, this is still very important because retaliation is a very big piece of why people do not speak up. So to put this in there really sends the message that companies need to protect employees who whistleblow and who speak up, because that is one of the chilling factors that stops them from coming forward, whether it's discrimination, whether it's harassment. So I think a lot of good things there. I think there's a lost opportunity in terms of holding employers accountable for failing to prevent harassment or to deal with it appropriately. But incremental approach, I think this is a great step in the right direction.
Yeah, and as we step nearer to that workplace fairness piece of legislation, the partners that you see and which Serene shared earlier, from SCCA to Law Society as well as Pro Bono SG, and of course the Labour Movement NTUC will be partnering and bringing you more primers come 2024 as we approach closer to the new piece of legislation.
Thanks, Patrick.
Thank you. I think it's very insightful. So glad to hear that the law has been evolving to meet with the changing landscape, as well as, I think more importantly, that there are resources out there that you can refer to if you need more help or to take more proactive steps to stop this from happening. So let's walk through some case scenarios so that we can see how perhaps the law applies in perhaps a realistic situation. A C-suite male executive, John, takes a fellow C-suite female executive, Mary, out for dinner and forcibly tries to plant a kiss on her lips. Mary speaks to HR, Emma, informally about this over drinks. Emma laughs and says, "Oh, but he's so cute. Surely you fancy him." Mary feels deeply embarrassed, stays silent, and doesn't file a complaint. Mary realizes that she's slowly being marginalized by John, excluding from key client meetings, and undermined in front of her team. Mary finally lodges a complaint, and the company terminates her employment under a pretext. I find this a very thought-provoking case scenario because here we're dealing with peers and within the C-suite context, which, I thought, this might not happen in C-suites, etc. So, Amarjit, what are your thoughts on this situation?
Okay, so this sounds like a nice hypothetical, but let me tell you, it's not a hypothetical. It's a real scenario in my experience that we've drawn from. Because I think, as Serene has rightly said, usually we imagine sexual harassment between superior, subordinate, male to female. In this case, the stereotype holds true, but it also happens the other way, right? So I want to be clear that sexual harassment is not always between genders. It can also be between the same gender, okay? Just so that we are very clear, because sometimes people don't realize that it can also constitute sexual harassment if it's a female sexually harassing another female, because that's not how we typically think of it, but that would constitute sexual harassment if all the other criteria is met. So this is a very this is an interesting example, one very close to my heart, because as you say, this is a C-suite female who is, very confident, very eloquent, and I think she was shocked that this happened to her. So I want to say this can happen to any of us, right? There is a lot of victim shame and blame that we impose on ourselves as people who go through this, right? Did we cause this to happen? Did we send wrong signals? Did we dress inappropriately and therefore indicate that, we are open to this? And I think those are questions that all victims of sexual harassment ask themselves, as did my client in this case, okay? It started off with certain text messages, inappropriate text messages, which she just laughed off because many people get inappropriate text messages. And I see this regularly because I have clients coming to me to say, what do I do about this? In and of themselves, depending on the degree and the severity, inappropriate text messages also constitute sexual harassment. But in this case, they celebrated a win. They went out for a dinner after the win in the workplace. And it was at this dinner that the C-suite male exec possibly kissed the C-suite female exec, who was shocked, right? She was completely shocked because she didn't expect this sort of inappropriate physical contact. She really didn't know what to do. She was very confused. So she was friends with HR. She went for coffee with HR. HR in this case is Emma, okay? So she went for drinks with HR, and she casually mentioned what had happened. Now, HR is almost always the first port of call, right? Because standard SOP, you must go to HR if anything goes wrong, right? HR in this case laughed at her and said, he's very cute. Surely you must fancy him. I think that shocked her even more because she felt as if what had happened was being trivialized. And it fed into her concerns that actually she might have been being overly sensitive. She might have led him on. Now, I've also had clients who had HR ask, what were you wearing when this happened? Or no, it couldn't have happened because the person is such a gentleman. I can't imagine him doing that. So these are all the kinds of off-putting remarks that HR have made in certain cases and can make, right? So in this case, it had the effect of shutting my client down. She became silent. She didn't say anything. But what she realized was because she wasn't playing ball, she didn't reciprocate the case, and she sort of tried to stay away and avoid the fellow C-suite peer. After that, she realized she was being marginalized. She lost key projects. She wasn't invited to key meetings with clients. Basically, the other peer took over her clients, and she was being undermined in front of her team. At that point, she said, okay, I'm not going to put up with this anymore. So she filed a complaint, and she took mental health leave because this had a very severe impact on her mental health. Now, while she was on mental health leave, the company terminated her, right? The company terminated her. And that to her was shocking because, hey, she finally complained, right? It took her so much courage to raise a complaint about this issue. And the company responded by terminating her employment. So what did she do, right? She came to see us at that point, and we then entered into a mediation with the company, because mediation is actually a wonderful way of resolving these kinds of disputes. Why? Because it protects the identity of the individuals and it's a confidential process, which means it allows parties to come to an agreed settlement in a safe space where they feel free to say what they want to say. And the process is not as taxing as going to court. So, Patrick, workplace fairness legislation also talks about mediation as a critical way of resolving these disputes, right? And it makes perfect sense. So in this case, we managed to get her a good outcome as part of the mediated settlement. But what I want to highlight here are the key failure points on the part of the company, right? So it was an MNC and they had good policies, okay? So they had great policies, zero tolerance for sexual harassment, etc., etc. So this is an example where on paper, the company was prepared to deal with it. They had the anti-harassment policies, anti-retaliation policies. They had everything on paper, okay? They also had grievance policies. So she followed the grievance policy when she complained. It was meant to be confidential whistleblowing, but it still filtered through to the company and had an impact on her, all right? Another thing is, even though you may have everything in paper, if you don't train your people to be first responders who are victim informed, who understand how to deal with such complaints, you end up in this scenario where either, my client could have been put off and not made a complaint, right? Or she would have felt as if she's not supported by the company and she would have left. So in many, many cases, sexual harassment is not reported because the individuals, the victims or the survivors would just leave because they can't face a person every day. And if they don't have confidence in the company, that the company is going to deal with this in an appropriate manner, despite the policies, right? Despite all the policies, you can have all the policies in the world, but if you don't train well, you don't implement well, people don't have the confidence to raise their complaints. So this is really a good example of what companies should be aware of in terms of how their HR and even managers should be trained in responding to complaints so that you don't push the complainants underground or push them out of your company, which is even worse.
I find it quite curious in this scenario that she informally speaks to Emma. Of course, it's over drinks and of course it's informal, but it's quite alarming. So does this mean that the company should have done something, or it's only if someone gathers the courage and do the formal way of doing it in writing, then the company is compelled to act?
So that's a great question, right? Because is it an obligation on HR's part if this is raised informally to deal with it? And I would say, had Emma, the HR, been properly trained, she would have recognized that this is someone in distress sharing their distress with me, right? And it may be informal, but firstly, don't trivialize, don't undermine the concern, right? Recognize that the person is in distress and is seeking help. The next thing to be done would be, look, are you prepared to file a complaint? And if the answer is no, it doesn't mean HR drops it. HR still needs to ensure the well-being of the individual, right? Whether or not they file a formal complaint, it's a duty of an employer to provide a safe workplace, right? Under health and safety, you have to provide a safe workplace. And if the person is constantly worried about being attacked or having some sort of inappropriate physical contact from someone who's in the same place, then you are not upholding the element of creating a safe workspace. And HR need to look into that. So even if the person does not want to file a formal complaint, HR should still ensure to the extent possible within their own remit to make sure the person is looked after, right? And whether HR should seek consent of the individual to inform their manager at least, so there are other allies who are looking out for the individual within the team or within a specific setting. So I think that's something that HR and companies really need to consider. Just because, and when HR are friends with employees, right, that's where the line gets blurred, because sometimes they may be sharing as their friend and not as HR, but HR still has a duty and obligation that they need to discharge.
Hindsight is always 2020. And as you shared, when it first happens, people may be in shock. And of course, when we look at this objectively, and we were not in that scenario, we may feel, actually, maybe she should have complained earlier. And I guess the question is, when you're working in a company, you really want to preserve relationships. You don't want to maybe pull the nuclear options of filing a formal grievance. What's your thoughts towards, is this, if things happen, should you constantly update HR, or you wait till maybe a certain point before you notify HR?
That's a very good point, because that is something that weighs heavily on people who encounter bullying, harassment, sexual harassment, right? Am I being too trigger happy? Is this serious enough for me to raise? They are asking themselves all these questions. And my advice would be, if you are feeling uncomfortable by what happened, if you are uneasy, you feel alarmed, you feel distressed, you should raise it, right? You should raise it sooner rather than later. Now, nobody can force anyone to report. Ultimately, that's a very personal decision. And as you say, as Asians, sometimes we are a little more hesitant to report because we don't want to be seen as troublemakers. We don't want to rock the boat. And it's not just that, right? There's very real fear of retaliation. People are afraid they're going to lose their jobs. I had a case where there's a single mother who is a sole breadwinner for her children. And she was very afraid, not just that she may lose her job, but for the physical safety of her children if she raised a case, because it would be obvious who complained. So these are very real concerns. The Wirecard whistleblower was a client of mine, and he actually received death threats, him and his mother. Now, not everyone receives death threats, right? That's an extreme example, because there was fraud. There was some serious financial crime involved, right? As we know, Wirecard is now no more. But there are real concerns that weigh heavily on the minds of people before they complain. Ultimately, if you are uncomfortable, if you are facing a decision of, do I leave because of this, you should raise it. Or if you dread going into work because of this, or if it's having a detrimental effect on your mental health, you should raise it.
I'm thinking about this, and I appreciate you shared the possible recourse and mediation might be the way forward. But actually, what is the possible remedies that you can get? It could be that they may choose, they may go back to work. Maybe they choose not to go back to work. So what are the recourse or remedies that such persons could have?
Okay, so I noticed Patrick was going to say something. Patrick, then I will jump in after that.
Yeah, I was just saying, because Amarjit has given quite a good spectrum of advice for employers and business owners out there, as well as HR practitioners. And I thought, my perspective, I want to give some pointers to employees or workers, because in this example, we have a C-suite employee. She knows how to get legal help. Yeah, but my main worry is the bulk of employees are not C-suite employees. You have your lower wage workers, your rank and file workers, blue collar workers, and your normal workers in the workplace. So they may not. I think exactly same sentiments. Worried about being prejudiced, worried that they might be marginalized, worried that there may be retaliation. So these are all fears. And particularly in this space of sexual harassment, my call out to all of you: don't suffer in silence. Please don't suffer in silence, because this will take a toll not just today, but for many years to come. So I think this entire mental health and well-being is of paramount importance, particularly in this day and age. So if there were some behaviors, and if you look at this, in fact, not hypothetical, but the actual case, as Amarjit said, it's really forcing a kiss. It's more than just passing, sexual remarks or other more insulting remarks. Is actually sort of like a criminal force, or in fact, to the extent of insulting her modesty. And I think for such cases, please don't suffer in silence. Please, escalate it. As I mentioned, in most of the unionized environment, usually I personally advise some of the employees and workers in the unionized environment when they face such cases, some even more severe. And I thought the key thing is we try to resolve things at the lowest level. Yes, alternative dispute resolution. But however, in some instances where it becomes, quite criminal in nature, it could be tantamount to outrage of modesty, even aggravated outrage of modesty, where it's done in the confined environments. That I worry very much. And I hope those of you who may be victims of such do not keep it, do not seek help, seek recourse, seek help. And if your HR, like in such a situation, is your friend or can't really give you help, then escalate it, as we shared earlier, the various channels. But more importantly, for employees and workers out there, particularly some of you who may not have the necessary knowledge. Key thing, because if you're going to escalate the matter, whether it's to be handled by the police, the courts, or even through the POHA process, please gather evidence. Gather evidence. Evidence comes in various forms: SMS messages, WhatsApp chat messages, comments online as well. But more importantly, sometimes it may be situations where you are unable to have all these evidence. Things like CCTV recordings are useful. We have seen cases like using CCTV recordings as good evidence that there may be advances or certain acts or gesticulating behavior. And over and above that, if you can, get witnesses. Witnesses are particularly in the workplace will be useful and highly instructive. And we know if it goes to a court of law, evidence will help you make your case and make your case even much more stronger if we go to that final option.
I want to jump in here. Actually,
Sure.
sorry, I echo all of Patrick's sentiments wholeheartedly, right? So never suffer in silence. There is always recourse, okay? And we've hopefully by the end of this, you will have some idea of what your avenues of recourse are, and never feel alone, even if you within the company can't find support. So Patrick's point on evidence can't be emphasized enough, right? Because ultimately, in order to establish any of this, evidence is crucial. Now, some of you may say, okay, CCTV is great, but what if it's verbal? What am I going to do? So particularly if we have bosses who are, narcissistic, or not just bosses, right? Individuals who are narcissistic or who are very smart about how they present themselves. And particularly if you are targeted, they will not verbally berate you, abuse you, etc. in front of others. So you may say, what do? I have no witness. The CCTV doesn't capture audio, or there's no CCTV. What do I do? What evidence do I find? Because they don't write anything. None of it is put down on paper, SMS, etc. What do I do? Doesn't mean I have no recourse. That's a simple example. In such a case, you may not have external evidence, but what you should do is to create a contemporaneous record. What does that mean? Sit down, type an email, right? What date, time, what happened, what was said, what went on, and send it to yourself. So at least there's a timestamp, there's a date. It happened, you captured it when it happened, or a day or two after. Why do I say capture it at that moment? Because our memories wear thin over time, right? I can't remember what I had for lunch yesterday, for example, right? So if 2 months later, I'm trying to write it down, the memory becomes a little bit fuzzy, the details are less sharp, and you may be accused of being self-serving for writing it down later in time. Because these processes can be very painful, and people will use anything they can when, against you if the opportunity arises. So create a contemporaneous record. If you have people who have also encountered similar things, like Patrick said, they may not have witnessed what happened to you, but there is strength in numbers where other people have also experienced the same thing. I'll share an example. In a recent sexual harassment matter, somebody actually spoke up and made a police report, which led to a particular individual being exited. What happened then is, because of the prompt and decisive action by the company, other people realized, okay, they've created a safe space for me, so we can also speak up. And they realized at that point that there were many others who had also experienced the same thing. But it's just that nobody ever spoke about it. So they didn't know that this was a common point of suffering, which they had all endured. And if only they had, spoken, or at some level tried to test the waters as to whether they're the only ones suffering. So evidence is crucial, right? In Singapore, you can also do an audio recording without consent if you really need to create evidence of, let's say, the person is shouting at you and there's no other way to establish it, then that is also an avenue that's open to you. But as Patrick said, sometimes the case is only as good as the evidence, because otherwise it remains a he said, she said. Even if it's a he said, she said, you should not suffer alone. You should still raise it, but any evidence you can put together will help.
Thanks. And this segues nicely into the next scenario where, as you pointed out quite rightly, sometimes things may not necessarily happen in writing. So the next scenario, we're dealing with the boss. An abrasive female boss targets a female employee in the team and repeatedly calls her stupid, incompetent, lazy, etc. The boss and employee are both from the same ethnic background, and the boss often tells the employee that she needs to be obedient and listen to her big sister and not challenge anything. The boss regularly invites the whole team out for meals, but excludes this particular female employee. The rest of the team have also started to exclude this employee from coffee runs and other team interactions. When the female employee tries to raise her concerns with her boss told her it's all in her imagination and she's making things up. The boss told her that the rest of the team would all agree that she's being overly sensitive. I think this is where it's, as you earlier mentioned, about the challenge of gathering evidence. Of course, you hope that your rest of your team would support and say, yes, I witnessed this and that. But in this case, it seems that the employee is facing perhaps an uphill battle where her boss is saying, oh, you're making it up, and the team doesn't really quite seem to be as supportive. So I guess maybe Amarjit and Patrick, what are your thoughts on such a challenging situation?
Yeah, in such scenarios, we know of some of our union members that come to the union because it's an external party of sorts, and that's where we come in and pick up on as part of a grievance of a union member. So that's usually the way our course of dealings whenever we have such grievances raised to us. Particularly when the whole, in some smaller companies, everyone is quite aligned in that sense, and you're the only one, the odd one out. So that's where we come in and try to resolve this. And if not being able to resolve, we might escalate it and try to conciliate it. Yeah, where needed, and of course, in such cases, if it affects the whole well-being of the person and it feels very aggrieved, there are other channels, for example, like TAFEP, because if it becomes a whole workplace harassment issue, or he or she is being discriminated against because of certain behavior, this is the brief facts, but so we'll try to establish a case, and if we need to, in that scenario that I shared, where our union leaders or NTUC will help stand in and represent the workers to the company, or to the company HR or some higher authority within the company, so that we can try to resolve things at the lowest level where possible, and if not, escalate it. Yeah.
Thanks, Patrick. An audience member has asked, perhaps this is for Amarjit. Obviously, if you put a recording device in front of the boss, it's unlikely the boss will act in such a way. And I think they've heard about how maybe in other countries like US, you kind of need consent to make secret recordings. So for Singapore, are you able to secretly record your boss and use that as evidence?
I don't recommend that as a matter of course, okay? It's really if you have nothing else that you can use to establish the bullying. For example, you don't have aggressive text messages or emails or other people who've witnessed it and you really have no option, then yes, that is an option open to you. Of course, it's not putting your phone in front and saying, here, let's start, right? You have to be more subtle than that. Otherwise, of course, the person will not be in their natural mode and will not behave as they normally would. Now, here's the thing. You're not trying to set somebody up. That's not the intention. The intention is not to also direct the conversation in a self-serving manner. That's really not it. It's just to capture the behavior of the person in their normal state as they would deal with you. Okay? It's not about entrapping anyone. I think that's crucial. Because if it's entrapment, the evidence may not be admissible. All right. So I have to caveat with that. Now, I want to just touch a little bit more on the scenario.
Yes.
Because I think this is important, right? This talks about tone from the top. Because workplace bullying and harassment rarely occurs in a vacuum. It's usually an environment that tolerates or allows toxicity to take place, allows this kind of behavior. And the tone from the top is crucial. So if it is the boss who is perpetrating the bullying or the harassment, it's normal for the team to mimic that behavior because it's a survival mechanism, right? They all have jobs they need to keep. So they either get with the boss or, they fear for their own jobs if they were to stand up and say, hey, maybe we should be nicer to the person, or if they were to, take a different view from the pack mentality. So this is the mean girls mentality, right? We go for lunch, we don't ask you, we do our own thing, but we don't invite you. And that the mindset of othering starts from the boss in this case, right? Now, it's interesting that the boss berates her, calls her all of this. And the same ethnic background is interesting because, Patrick, earlier we talked about discrimination and harassment. Discrimination and harassment often coexist in the same plane.
Yes.
Okay, because discrimination is a permutation of harassment. It can take the form of discrimination and othering, right? race, religion, all the protected characteristics, age, pregnancy, various things, right? As we say, disability, mental health, all those things are used to as reasons to harass, right? But in this case, same ethnic background is very interesting. And I've actually encountered this in real life in several scenarios where the ethnicity is used as a means of trying to force obedience, trying to force compliance. You don't ask questions, just do what I say. It's the big sister hierarchical mentality. Now, studies have shown that bullying and harassment is more prevalent in hierarchical workplaces and in workplaces where the tone at the top is discriminatory, right? Or the tone at the top is a certain way. So this case is interesting because ethnicity is used to try and, perpetrate the harassment instead of discrimination. But it happens. It also happens. Yeah, particularly within hierarchical communities, for example. So I think this is very interesting. Gaslighting is also very interesting because that comes up in here when the boss tries to diminish her concerns and says, no, there's nothing. When she said, maybe you can, these are my concerns, maybe you all can include me, or you can maybe not use those words because it makes you very uncomfortable. And the boss denies the employee's version of reality by saying, no, you're imagining, you're being overly sensitive. And gaslighting is particularly insidious because it undermines a person's sense of self and the person's sense of reality. So this is a really good example because it happens commonly. I mean, we hear, Patrick, I'm sure you hear examples of this all the time. Yeah.
I observed that, although the boss kind of started that behavior and the team took the cue from the boss. So in this case, would it be both the boss and the teammates who are doing harassment, or is it only the boss since he started it?
I think the environment is an environment that allows harassment, right?
Mm.
Because the boss is the one who verbally abuses, but the toxicity and the feeling of othering is also reinforced by those who exclude. Marginalization is also a form of harassment, right? To marginalize, to exclude. The example I shared about the glass meeting room, right? Now, there is a form of dismissal in Singapore, wrongful dismissal, which is actually constructive dismissal. What is constructive dismissal? Constructive dismissal is where a person resigns, but they actually don't resign of their own free will. They resign because they feel they have no other options, given either cause of conduct by employer or cause of omissions by employer, right? So in such a scenario, if the boss speaks in this way and the teammates treat her in this way, exclude her, don't invite her to meetings, don't give her critical information that she needs to do her job, because it usually filters across these different facets, right? The person may feel that they are no longer contributing. It reduces their productivity, reduces their morale, and at some point they may leave not because they want to, but because they have no other option. Then technically, they can say they've been constructively dismissed. They can actually raise an argument for constructive dismissal. They may not say it's because of harassment or bullying, but because of the entire course of conduct, which left them with no other option.
Which commonly we call it forced resignations.
Yes, exactly right. Exactly right.
Patrick, do you have anything to add to that?
Yeah. So I just feel very strongly, and then if you are in really such a toxic environment, usually I would advise members to take the necessary course of action, even not continue in this company. But more importantly, is I just want to emphasize again the importance of mental well-being and if there are employers that are tuning in out there, if this is happening in your workplace, please, these are warning signals and lights, and this is our advice from the three of us. I think it's important to nip the problem at the bud. Such things should not be happening. Be extra mindful, because for employers out there, these days with social media, with what's happening, we've seen cases. This is the real cases happening. And employers getting into trouble as well. This will cause severe reputational loss to your company. You could be a department, you could be a small entity right here in Singapore, but maybe your company may be headquartered somewhere else, and it may be a listed company or still. So be careful, and make sure the workplace should be a harmonious one. And more importantly, engage your employees, because some may be suffering in silence. You may not know because it may be a hierarchical, organization. Something happens downstream, and it is worrying if it's such happening. So I think it's important to, including HR and human capital practitioners out there who are tuning in, to get a good pulse or good sense of the ground, so that things like this don't cause. It won't explode in your faces when it gets a bit acrimonious. Yeah.
I want to chime in here because I think what Patrick has said is absolutely right. Employers, there is a very strong business case to create a safe workplace for people, right? If they feel unsafe, if they feel like they're bullied, harassed, sexually harassed, it has a severe impact on the companies reputationally, and you lose good people over time. And if you don't have an ear to the ground, as Patrick has said, you may not even know why, because the reality is in exit interviews, people are not going to tell you if they haven't already complained. So you will be blissfully ignorant. You will have no idea why suddenly in a particular team, there are so many people leaving, right? So sometimes it's really about digging deep to find out what's going on. And you can only do that when you create a safe environment for people to speak up, for them to feel safe enough that their voice will be heard and they will not be retaliated against, or they will not have any kind of negative backlash, right? So there is definitely a business case, reputational harm aside. Companies sometimes think, oh, it doesn't matter. We will just settle it. We'll just pay them money to make it go away. Now, that doesn't solve your problem, because the person who is the victim or the survivor would have long-term lasting damage. And let me tell you that we've had some very large settlement sums, right? But the person is never made whole because, they have PTSD, they have anxiety. Some of them have, long-term mental symptoms that have arisen because of the trauma. And they go back to broken families because they start to change and it impacts their family dynamic. So
it's a vicious cycle.
It's a vicious cycle. So you damage someone's family. You can throw money at them, but it doesn't make things right. And ultimately, if this keeps happening, the company gets a reputation for not looking after their people. Over time, you can't attract good people, and there is a real cost if you don't look after your employees. So like Patrick said, employers, please take note. There's a lot you can do, should do, and must do.
No, it's such an important reminder that, just because something happens in the workplace, that the impact is only in the workplace, that if the bully moves on or the victim moves on, it doesn't mean that the impact from that workplace harassment stops, because as you shared, it could be trauma and unfortunately might spill over to that person's personal life. One question an audience member notes is, in these scenarios we've mentioned, it's full-time employees, and they're quite curious, what happens if it's part-time workers, or what happens nowadays given that there's more gig workers? Would it be considered as workplace harassment?
Yeah, maybe I'll chime in on this and respond to that. So part-time workers or part-time employees are still employees. So the same rights that are extended to full-time employees are also extended to part-time employees, particularly as we are referring to workplace harassment, workplace issues, even union representation is available to both part-time and full-time employees. So that's in a contract of service or in a pure employment relationship. So you referred to the gig arrangements, i.e. contract for service or independent contractors. Now we usually call gig informal workers in various nomenclature. This is a situation where there's no employment relationship. Unfortunately, it could be a buyer of your service, or you could be working in a place where you're just providing a service in a particular workplace. So, well, in a way, it's workplace harassment, but however, because of the employment relationship, there's no sort of a duty of the employer to the employee. However, all is not lost. We alluded to the POHA, Prevention of Harassment Act. So that applies also to gig workers. So regardless of whether you are a full-time employee, part-time employee, or any, basically providing services or worker there, if you face any of those, protected characteristics, or should I say areas of offense like being insulted on, being threatened of violence, and a whole series of stuff that's provided in section 3, 4, 5, 6, 7, you can seek recourse through the POHA courts. So that all is not lost for gig workers. That's the usual. And over and above that, the civil claims, the criminal sanctions through reporting to the police, if there's, for example, voluntary causing hurt or verbal threat being hurled at. So the criminal or the penal sanctions are still in existence if you are a gig worker. Personally, we know because many of our gig workers, particularly during the COVID period, the pandemic period, have to face, particularly the delivery riders as well. The food delivery riders, they actually deliver food. Sometimes they get into skirmishes, etc., and face difficult customers and clients, and sometimes even merchants. So therefore, there are instances where they get into skirmishes, and we do advise them, because actually with the labor movement, we actually have a few gig workers or associations that we have formed, National Instructors and Coaches Association, National Private Hire Vehicle Association, to better look after those who are Grab, Tada, Gojek, and private hire vehicle drivers. We have also the food delivery champions. We call them the NDCA, National Delivery Champions Association, as well as those in the creative sector. So these are some of the associations that we have formed, and to look after some of these more vulnerable freelance workers. And lo and behold, one of the key developments, since we are on this topic of gig workers, is there was a tripartite, or should I say, advisory committee looking at platform workers in particular, because having in Singapore today, we have something like about 200,000 freelance and self-employed workers. The Ministry of Manpower call them own account workers, and they are in a contract for service arrangement. And we have identified the platform workers as a more vulnerable group. Not just lower wage, but because they're subjected to, for example, the algorithms of the platforms and other areas. For example, if they get into trouble, whether they have been harassed or they've been bullied by customers, or even merchants, because they serve merchants as well when they pick up the food. And therefore, all these, we want to look after them. So there's actually the advisory committee has already fleshed out a report, and we'll be expecting to see some developments in terms of legislation to better protect them, not just for retirement adequacy, for training, and also for workplace injuries. And more importantly, interesting development is union representation. So that's where the labor movement and my colleagues and myself, we're looking at. We're still really on the drawing block, because this is a very new area, in the sense that many parts of the world are actually eyeing and looking at and scrutinizing at us, and how we're going to develop this piece of legislation, whether it's going to be imbued within the Employment Act, or outside the Employment Act, within the Industrial Relations Act, or outside, or a very new piece of legislation. These are all still in discussion and negotiations, and we are trying to see how best to look after the interests of this category of workers, where they are not employees, they are freelancers, but however, they are platform workers who may be very vulnerable. So watch this space. There'll be some developments coming up next year.
Thanks, Patrick. I think it's quite heartening that we're looking into protecting, or looking into the issues of the gig workers, given that there's an increase of number of gig workers in Singapore. So let's move on to the Q&A segment. And a gentle reminder to our audience, please feel free to submit your questions through Pigeonhole. So I think the first question is for Patrick. This audience member commented, and it's a very highly upvoted comment, is that some HR admin staff to carry out HR work, most are not trained to deal or carry out with whistleblowing, or know to how even to start doing it, or dealing or rolling out such policies. How or has the government pushed for a better trained HR department in this aspect?
Yes, thanks, Serene, for that, and thanks for that question. That's something that myself and the labor movement team has been lobbying for, and lo and behold, yes, we now have an Institute of HR, or Human Resource Professionals. This institute actually sets some competency standards and some certifications for HR practitioners. As we are talking today, there are something like more than 30,000 HR practitioners in Singapore. Majority of them, 90% of them, are Singaporeans. And we have gone on this journey to better train and equip them and certify them. As an industry certification, at the same time also as sort of giving them knowledge on some of these important areas of labor legislation, labor practices, tripartite guidelines, advisories, which they need to be aware of. And as part of this certification, they are required to undergo some form of examinations, and tests and quizzes. And as part of that certification requirement, some of the modules that are covered, I'm familiar with them, and some of the compulsory modules, include learning or getting the relevant knowledge how to manage such cases, as you have alluded to, the grievances on the ground. All these, they are a whole spectrum of tripartite advisories, standards, guidelines, even law. And therefore, as part of that certification, they will be acquainted with and provided the knowledge of all this wide spectrum of stuff, including working with unions and the tripartite system, etc. So this is one big journey that we are on. I'm glad to share that today there are more than 5,000 who are trained in this, but it's still a journey because, as I shared, there are more than 30,000, and I'm glad to share that. Well, at least for the large corporations, well, at least one HR practitioner within many of these, most of our large corporations have already undergone this certification. But we hope that it be more pervasive and that more will jump on the bandwagon. So that's for industry training certification standards and bringing them up to speed. Of course, the labor movement, we work very, very closely, at least for a unionized environment, to keep our HR practitioners up to speed on some of the developments in this space and through our various sessions. So some of you who are HR practitioners out there, if you find that some of our legal primers are useful, we organize quite a number of them almost quarterly, and they are in but with a particular focus because of this Law Works partnership between NTUC and the Pro Bono SG, particular focus on workplace issues. So stay tuned, stay connected, and come and attend some of these sessions to keep abreast of what's happening. But otherwise, I said this is one big piece. Ministry of Manpower has actually fleshed out HR plan or human resource plan for the industry to uplift, upgrade, and of course increase their knowledge and capability to manage now the bigger and bigger spectrum. Now we even have gig workers to manage, for HR to manage. So I think it's getting a wide spectrum, and no, I totally agree with you that we need to raise standards. Unfortunately, the bulk of our companies in Singapore, we have more than 200,000 companies. Bulk of companies are small and medium enterprises. Some are micro SMEs, some are even startups. They may not have the bandwidth and capacity to do this. So that's why we alluded to some of the best practices that's available online, templates, SOP to HR practices. If you're SME, IHRP actually conduct free programs for you to acquaint yourself with some of these and to imbue some of these practices, procedures within your companies and your SMEs. So don't, there are lots of resources, lots of training, some mostly complimentary and really at low cost, and many of them funded. So make full use of these so that, and if some of you who are employees or workers or even gig workers working with SMEs, and if you think things are not up to mark, encourage them to jump on the bandwagon and attend some of these programs.
Thanks, Patrick. I think you answered the question before I could ask, which was, SMEs have tight budget and is there funding? But it's glad to hear that there's free resources or low-cost resources out there. Amarjit, you wanted
I want to
add
jump in, yes. So not free or low cost. Catalyze is Aware's arm that does training, okay? So for specific training, look at Catalyze, look at what they offer. Law firms offer training. And more than that, if you are faced with a scenario where you really don't know where to start, you've had a complaint come in, you don't have grievance procedures, you don't have an investigation process, and you don't know what to do, you can engage independent law firms to come in and run the investigation for you. Because the key word is independent, right? So in certain scenarios, I'll give you an example. If there's a CEO who is very close friends with the perpetrator, and the employee feels very unsure about raising a complaint because of fears that the perpetrator will be protected, in those cases, HR come to us to say, look, we really don't know what to do. We need an external law firm who's independent because there are some systemic issues here, right? So that's always an option as well. So if you're really overwhelmed, there are still options. Quite apart from getting training, if you're faced with an urgent scenario, reach out. There are people who can help.
Thanks, Amarjit. And just a note to our audience, if you look at the chat, we have dropped in some very useful links for you to find out more information about NTUC as well as the HR courses that are mentioned. And I think, Amarjit, your response is in line with the next question is, what if HR is the perpetrator, or what if HR is being bullied by the management because people's first instinct is let's go to HR. Any thoughts on what's alternatives?
Yeah, so that happens, right? HR can be the perpetrator. Someone in HR, who may not be aware of their own behavior or who deliberately is misbehaving could be the perpetrator. So then what do you do? Now, hopefully you have managers who are understanding, who can help you. Or ultimately, if it's not your line manager, go to management, right? but give the company a chance to resolve this, right? There are always people above HR. So you should consider within your organization which is the most appropriate route through which to escalate the concern if HR is eliminated because HR is a perpetrator. Now, what if it's happening to HR? Who do HR go to then? Because they are the ones who are supposed to handle this.
Yes.
Now, again, HR should then consider who within management they should escalate this to, right? Because if they as an organization, if they as the part of the organization are paralyzed because they are the ones who are on the receiving end, and they, if they can't help themselves within the framework, obviously they can't start the investigation, right? So then they may need to reach out to management. And in such cases, management may say, okay, HR will not investigate this. Given HR may have raised a complaint, we get in external investigators. Or we convene a different panel within the company who's going to look into this. So they also can look for internal solutions. They don't always have to go external.
Another question from the audience is, I guess sometimes victims, they feel, look, I'd rather just leave, and not deal with this. But what happens if, after they leave the company and their former bully still in the company? And so when his new employers, when he tries to find new jobs, they would seek references from the company. And of course, the bully continues in his behavior. Now that the victim's no longer in the workplace, is there anything the victim can do? Can the victim tell the company what's going on?
Okay, so that's a very good question. I can understand the frustration built into the question because the victim didn't do anything and left because maybe they felt helpless or they didn't think they would get the support of the company. But yet it looks as if the perpetrator has gotten away scot-free, right? And is continuing to move from job to job and is unscathed by what they've done. There's been no cost they've had to pay. So I can understand the frustration, the resentment built into that. Can they do something? Of course, they can inform the company what their experience was while they were with the company after they've left. They can say, look, upon reflection, I feel duty bound to inform you that this has happened. In fact, we've had cases where, because of current investigations, ex-employees have also come forward to say, actually, we've had issues with the same perpetrator. And that's more common than you realize because they feel at that point that they are safe to speak up. What if no one else has spoken up? You can still speak up. Now, people may ask you why you waited. And the reality is, while you are still within the company, you're vulnerable, right? You can lose your job, you can, be demoted, etc., etc. After you've left, you may feel like you're in a safer space to raise it, right? So if that's the case and they feel like they should raise it, they can, but it doesn't mean the company is going to then give a bad reference. It's not as direct as that. But nonetheless, if they would feel better for doing it, then they should.
Thanks. Patrick, anything to add?
No, yeah, but I was just thinking aloud if there's a wrongful dismissal or false resignation, and you have actually wanting to go for a more economical or access to justice, for example, like through the Tripartite Alliance for Disputes Management, or through the Employment Claims Tribunal, or through the Ministry of Manpower, or even to the unions. I just want to take particular note that there are limitation periods. Yeah. Well, is depending on what kind of action you're embarking on which platform or which route, it varies. So I just wanted you to take a particular note that there's some limitation periods if you want to use all these various form of dispute resolution.
Same for POHA. So that's a very good point. Take note of the limitation periods before you choose your avenue of recourse.
Good thing to note, because I have received a number of questions. I think, after listening to what constitutes harassment, I think people are reflecting that, actually this happened to me, but a couple of months have passed. Is it too late? Do I need to wait for it to happen again? Then I perhaps will speak up.
No, you don't need to wait for it to happen again. The intention is to stop these things from happening entirely, right? So you shouldn't be sitting and waiting for it to happen again, because I think that's the worst position to be in, where you're just bracing yourself for another attack or another unwanted approach. So if it happened a few months ago, it does not preclude you from raising it. We've had many cases where it takes survivors or victims quite some time to muster the courage to raise these things. Okay, so a couple of months is not that much of a concern, because particularly if you're still there, right? It's still an ongoing threat. It's still an ongoing concern, and they should raise it. They shouldn't just be waiting for the next incident, because the hope is that if you raise it, it can be nipped in the bud, as Patrick has said, right? Try and stop it. Either the company should take appropriate disciplinary action. Okay, so that's crucial. It's to nip this kind of behavior in the bud. And if the behavior is not that serious, then there's a whole spectrum of measures the company can implement to stop this from happening, both to the person who has encountered it previously as well as to others.
So a question from the audience is, it touches on retaliation. So in most employment contracts, you're able to terminate by just giving notice. And obviously, some employers may not say, look, I'm terminating you because you complained against me. Okay, I don't think it's, so cut and dry as that.
Yes.
So what happens if you're just terminated by given notice? I mean, how do you prove or show that it's retaliation?
So that's a brilliant question, right? That Patrick was smiling because I'm sure we have both heard of this many times, right? So contractual termination is one, but it's worse when suddenly you're a top performer and you complain, and suddenly, the company takes you down a couple of notches in your ratings. You start getting negative reviews, negative feedback, and you are put on a PIP. So I have clients who complain and then they are put on a PIP. I have clients who complain, go on mental health leave, and they're terminated contractually, just given leave. And now, how do you prove it? How do you prove it's retaliation? The more I guess parallels, or the more connections you can draw between what has happened to you, your complaint, and the subsequent action, the better placed you are to draw a line, to join the dots between the complaint and the termination. And wrongful termination also comes into play here, because if the company gives you a reason for termination that's untrue, then you can challenge it as a wrongful termination. Okay, you can also challenge. So if the company says poor performance, the company has to prove it. So you can put the burden of proof on them to say, actually prove it, because I've consistently been ranked top in my team or whatever, and this has come out of the blue, and it is on the heels of my complaint. If they say misconduct, which has also happened, Patrick, I don't know if you've encountered, where suddenly some trumped up misconduct charge is put on the employee who complained, then the burden is also on the company to prove that. Okay, so employees should be very clear on these kinds of things. Now, in Singapore, an employer can dismiss without giving a reason if it's contractually done and if it's with notice, right? And I think that's really the question you've asked. But at that point, you can probably say they are terminating me, they are retaliating, and it's wrongful termination because I raised a valid concern. And then they can go to the avenues of recourse we've discussed.
Yep.
Thanks, Patrick. Anything to add?
Yeah, so, I mean, Amarjit shared about the, usual recourse through the Employment Act and as well as through the provisions that are provided. And in the unionized environment, in some of these cases where such occur, where there's sort of like unfair dismissal, then we have an additional recourse because of the Industrial Relations Act. We can actually escalate it to a minister of manpower to hear some of these cases. So when we feel strongly, we will try to conciliate, but when we feel that it's a clear cut of unfair dismissal, we can actually escalate the matter and for minister's decision on it.
Another question from an audience member is, as you highlighted, it takes time for victims to realize, and even if they realize, it sometimes takes them the courage to try and do something. But what happens if the bully has already left the workplace? Do you still complain to employers so they take note of it to improve processes, or do they go after the bully personally? Any thoughts, Amarjit?
So that is a very, very brilliant question, because it happens more often than not, right? Sometimes it happens that the person raises a complaint, the bully resigns.
Yeah.
Okay. And then what do? They have no resolution, they have no closure. And I think part of the process for victims or survivors is to get closure, because otherwise they can't move on. And that's part of the problem when they just leave, because they carry that angst along with them. So let's say the victim has waited a while, finally musters the courage, is going to complain, and lo and behold, unconnected to this issue, the person leaves. So what do? Do they still tell the company? Look, because the person's gone, the immediate threat of retaliation from the individual is removed to some extent, right? So as a responsible corporate citizen, should they report? Yes, if they feel safe, they should. Because there's a wider obligation to notify the company that this is what they have had to endure, right? Now, in terms of actual immediate impact on the victim, on the perpetrator, it's not really there, because the perpetrator's left and there's not much the company can do. So that goes to your next part of the question, which is, can they do anything against the perpetrator? Now, Patrick has talked about the time limit within which certain claims need to be brought. So long as you are within the time limit and the criteria for the claims are met, there's nothing stopping an individual from seeking recourse, even if the person has left. Because for example, POHA offences are not strictly workplace-related offences, right? So even though it happened in the workplace and the person is no longer there, the action is still valid. Same with criminal complaints. So I don't think that should restrain them from seeking recourse.
Thanks. Perhaps the next question is for Patrick. There's a little bit of confusion because I think they appreciate that there's various schemes, but when should someone approach TADM versus Employment Claim Tribunal versus MOM and versus maybe NTUC?
Okay, well,
which one do they pick?
Sure. Not to worry, because I think the first port of call will be the Tripartite Alliance for Disputes Management, TADM for short. If you face salary-related claims, salary-related claims, as well as wrongful dismissal. For the simple reason is that my colleagues in the NTUC, we are also cited together at TADM. TADM has the Ministry of Manpower officers as well as our NTUC officers there. So they actually, when you triage the case, if it's an NTUC union member, we actually put them on a sort of like a fast track to help them and provide assistance and support to help them to resolve the matter and to give them proper advice. And if need be, it can if we realize that actually they are actually already members of our unions, we will get the union leaders and unions officers from the union to help them and walk the journey with them and represent them. So that's the first port of call. Of course, there are some of you who are working in unionized environment and you're union members and there are union leaders on the ground with you. And we are very actively in quite a number of places. And therefore, that will be the easiest port of call if you are in your workplace and you need some support and some representation and a listening ear. And for Employment Claims Tribunal, Employment Claims Tribunal, whether ECT or we call it ECT for short, and MOM, it really depends on the case. But first port of call is definitely still TADM. They'll try to resolve the dispute through alternative dispute resolution mechanisms, mediation, for example. And if we feel that's a strong case and it cannot be mediated, parties don't agree, then it will go for ECT hearing. That's one route. Even though in some cases you go to the union usually will escalate. If they need to escalate and or the case comes to a deadlock and there's no resolution, we usually escalate it to Ministry of Manpower, where at the same time also alternative dispute resolution through a conciliation. We call it conciliation at the Ministry of Manpower. And when needed, in some cases more acrimonious, either escalate the case, like I mentioned earlier, to minister, if it is unfair dismissal case, or we may even route it to an ECT resolution, or even to the Industrial Arbitration Court if it's within the perimeters of that of the jurisdiction of IAC. So it all depends. But I said these are the two easiest port of calls. TADM, especially if you're a non-union member. Even you're a union member through the unions, if your company is a unionized environment. And if you're a union member who is not in a unionized environment, just go TADM. My colleagues in NTUC are there to assist you.
Thanks, Patrick. Sadly, we are running out of time. So I'd like to ask the speakers to give one key takeaway. Maybe Amarjit, would you like to start first?
Sure. I think the main thing that needs to be highlighted is bullying, harassment in the workplace happens. Don't feel alone. My hope is that today's session would have given you the sense of, firstly, what is bullying and harassment, so you are informed. Now, we all know people, whether ourselves, our family members, our friends who've suffered this, right? So, if you know of anyone, be an ally, right? Employers, please take note of all the points we've made. I think it's critical you set a safe and create a safe space for your employees. You look after them. And our hope is that we've given you enough examples of how you can try to get help, avenues of recourse. And our hope is really that as the years go on, the need for this conversation lessens because people become more evolved and recognize that this kind of behavior is unacceptable in the workplace.
Yeah. My key takeaway, I echo what Amarjit shared, but more importantly, I think there are developments in this space, lots of developments in this space. And I feel strongly because the labor movement as part of our Every Worker Matters conversation in the Renewed Workers Compact. I think one key thing that came out of it was, particularly with workers, was mental health and well-being. I thought this is very important in the workplace. And what we have discussed today, giving you the various recourses, is to ensure your mental health and well-being. So there's support out there, there's help out there. Don't feel alone, and you know, you just press the right buttons, make the right call, and look for the various help that's being provided to each and every one of you. If you don't like I said, don't suffer in silence. I'm particularly worried because as what Amarjit shared, rising number of sexual harassment cases for one reason or another, and we hope with the upcoming pieces of legislation, guidelines, and support measures that all of you can tap on those to make sure that you have well-being, and for employers out there, provide a safe workplace for your workers.
Thanks, Patrick. Thanks, Amarjit. I think for bringing light to this issue, which I think it's you know, because most people work, so it's good that we're all mindful of this. So we have to bring our Q&A session to a close. At the end of this webinar, a survey form will pop up on your screen for your completion. We appreciate your comments as it will be used to improve future webinars. Next week, we will have 4 webinars happening at 7:30 p.m. covering divorce under Sharia law. The English version will be on Monday, 6 November, and Malay version on Wednesday, 8 November. There's also Protect Yourself, How to Spot and Avoid Scams on Tuesday, 7 November, and the Mandarin version of What to Do if you are facing or knowing anyone who might be facing family violence on Thursday, 9 November. These and many more webinars is part of the Law Awareness Weeks at CDC 2023. You can scan the QR code or visit the website go.gov.sg/lawcdc2023 to register for this webinar or the many more webinars available. If you're facing any legal queries and are keen to register for a legal clinic session, you may write to help@probono.sg. We would like to express our gratitude again to Patrick and Amarjit for sharing their knowledge and experience with us. So with that, we would like to thank all of you for attending today's session, and may you have a great week ahead.